The U.S. Supreme Court has rejected a challenge that targeted the availability of the widely used abortion pill Mifepristone. In a unanimous ruling handed down Thursday morning, the justices found the case lacked legal standing. A group of anti-abortion doctors and medical associations brought the suit against the U.S. Food and Drug Administration, which questioned the FDA's decisions that made it easier to access Mifepristone.
This is a unanimous decision. Justice Clarence Thomas is the only justice who wrote separately. It was a concurring opinion. But I will say this case, yes, it has to do with abortion and the conversation you've been having, in the sense that if the case had gone another way, it would severely restrict access to one of the pills that the majority of women who obtain abortions in this country use. But this case has everything to do with standing. So if you think about where would this case appear in a constitutional law textbook, it's under the standing doctrine. It's not under reproductive choice. This case, yes, is the first big case after Dobbs where we're talking about reproductive choice. Dobbs, of course, being the case that overturned Roe v. Wade. But it doesn't have anything to do with whether or not abortion is a protected liberty under the Constitution. It has everything to do with these doctors, this medical group, whether or not they could walk into the courthouse doors and say, I was injured enough to be able to move forward with my suit. I think this is a unanimous Supreme Court saying to the Fifth Circuit that allowed this case to continue, no, you got it wrong when you were talking about who could bring a federal case.
The Supreme Court ruled that the plaintiffs here didn't have standing. They were doctors who didn't prescribe mifepristone, one of the pills commonly used in medication abortion. They couldn't show that they were facing any particular injury from the Food and Drug Administration's approval of mifepristone some 20 years ago. And under very standard standing doctrine, the Supreme Court said that these plaintiffs just didn't have the right to come into federal court and challenge the FDA's decision-making.
This medication, mifepristone, has been used in the United States since the year 2000, and use of this medication has been growing consistently. It now makes up about 63% of all abortions in the US. So a decision against this medication would create enormous barriers for people who need this medical care.
These are not doctors prescribing mifepristone, and these are not doctors who were forced to treat people who had rare side effects to mifepristone. So part of what you heard in oral arguments, part of what you're seeing in the decision today is the court saying there are federal conscious objections. There are laws that protect people who have genuine concerns, moral and religious concerns about treating people under certain circumstances. You heard Justice Barrett mention this in oral arguments. She said, does this somehow undermine the conscious objection laws? And they said no. So what we have here are doctors, I think it's worth repeating, these are not the doctors who prescribe mifepristone. These will not be the doctors who are forced to treat people who have those rare side effects. And I think those two things were fatal to their claim here.
Well, part of their argument was that there's potential for people to need care after their abortion. And it's true, some people may need care, especially if they don't have an abortion provider near them. They may need additional care. But in this case, the plaintiffs were unable to demonstrate that this is a sufficient burden, that because medication abortion is so extremely safe, there isn't enough here to say that these regulatory approvals should be rolled back.
It tells us that the Supreme Court is enforcing standing doctrine. The conservative movement for many years had been focused on closing the courthouse doors to litigants. This isn't a close case. It's an easy case. It should have been an unanimous. And I think that's across the board. It's not a political issue. It's not an issue of abortion, but rather issue of standing doctrine. I do think it also is a reproach to the Fifth Circuit, the Court of Appeals that oversees the state of Texas, where this case was filed with Judge Kaczmarek. I think it's a reproach to that circuit, which has often been far out of step, even with the radical goals of this extremely ideologically right Supreme Court.
It does provide some peace of mind, but there 14 states still completely ban abortion. And so all of the barriers in those 14 states, as well as others that restrict access to abortion, they still remain. People are still struggling every single day to get this care that they need.